Hey, what's going on, everybody? So I wanted to change the pace up a little bit, and I wanted to do a video on getting rid of a judgment against you. Now, some of you may have gone to court and you've lost, and you've got this judgment hanging over your head, and you're trying to figure a way to deal with it, how to cope with this judgment. Well, there's a chance that you can get rid of that judgment, okay? And this is probably going to be a two-part video series because a lot of this information can be a little boring. So I didn't want to have one big video with a lot of boring information. So I'm going to break it up, and there's going to be a two-part video for getting rid of judgments against you. But essentially, we're going to look at how you or a family member or a friend can deal with a judgment against you. Now, in some cases, you have to act quickly, and then in other cases, you can basically get rid of a judgment that's been hanging over your head for decades, and it's been a thorn in your side, and you want to get rid of it, right? So, if you're in this situation, you got this judgment, and you know you need to get rid of this judgment so you can live your best life, some of this information is probably going to be useful to you. Now, of course, I'm not a lawyer. I don't pretend to be a lawyer. I'm just some guy on the internet reading information. So take whatever I say with a grain of salt. But with that in mind, if you're representing yourself or you have an attorney, this information is going to be good information that you yourself can use if you're representing yourself, or maybe this information is going to be good information so you can have an intelligent conversation with your lawyer, right? So basically, when it comes down to getting rid of these judgments, everybody knows that sometimes you get in a situation where the judgment against you is wrong, and you know the judgment against you is wrong, and you just simply don't know what to do about this bad judgment. So this information might be useful to you. Now, everything I'm going to give you is coming out of the Federal Rules of Civil Procedure. And of course, all states have their own specific civil rules and procedure, but most of them, majority of them, are modeled after the federal statute, right? So the federal statute is going to be the template, and then I believe the states tweak their civil rules and procedure from there. So there are some situations where some of these rules have been enhanced to protect your rights. So your state could have additional mechanisms to get rid of a judgment against you. So let me know if you want me to do a video specifically on your state and how to get rid of judgments as it regards to the court system in your state. And of course, that request is always going to be expedited when it is basically preceded by a donation. But at any rate, even if you don't donate, let me know if you want me to do one for your state, and I'll put it in my list of things to do. So, with that said, let's go ahead and get into it. So, the first thing we're going to look at is that we're going to look at Rule 59. Basically, Rule 59 of the Federal Rules of Civil Procedure tells you that you can have a new trial, or you can alter or amend a judgment against you, right? So a new trial, in my mind, in my opinion, is going to be what you want when you have a situation where you just had a totally unfair proceeding and the trial was 100% bogus in your eyes, and you want to have this trial all over again. Well, you can ask for it according to Rule 59, right? And you also have the option of altering and amending a judgment against you. Now, I think this scenario is going to be specific to your situation. I don't know what your situation is, but in my mind, there are a few possibilities on why you want to alter judgment uh, in the case that you were involved in. Now, the first reason that comes to mind doesn't really fit into the context of this video, but let's say you won. You won the judgment and you felt your case was pretty solid, but you didn't get the judgment that you want. Then you have the opportunity to go back, ask the court to open up this case and basically look at the case and give you a better judgment, right? You know, maybe they gave you a judgment for $1,000 and you felt you needed a judgment for $30,000. I don't know. Well, you can go back to court and you can ask them to give you a better judgment. Now, another scenario which this fits in my mind is that you have a judgment against you, but that judgment is just too unbearable. You can't handle the judgment, and you need to somehow take the edge off the judgment, right? And that's possible. That's possible. You can go back to court and say, hey, you know what? Look, this judgment is just too devastating. There's no way I can live with this judgment. I might commit suicide. I might just go crazy. I don't know what I'm going to do if I don't get rid of this judgment. Now, of course, you have to have some legal grounds for asking for it. But, you know, this is just an example of one of the reasons why you want to go back, is that the judgment is just simply unbearable, right? So you can go back under this situation and ask for them to at least take the edge off. Maybe it's a situation where you know you're wrong, and it's just that the judgment is just unbearable and you need something to dull the edge or just take the edge completely off. Rule 59 is a mechanism that you can use to take off the edge of a judgment. And another situation where I think this would apply is in a situation where you basically want to eliminate, you don't necessarily want to have a new trial, but you want to basically make the judgment null. You want to make this judgment null, and you want this judgment not to have any real effect on you. So you can go back to the court and you can ask the court to modify the judgment in the way that it doesn't really hurt you, right? All these things and more are possible under Rule 59. So let's talk about Rule 59 really quick. So basically, Rule 59 is going to be applicable in two situations. And actually, there are only two situations in my mind. Actually, let me think about this. So there's three situations in my mind which you can have a judgment against you. And I'll mention first, you can have some type of administrative hearing. It looks like this doesn't apply to an administrative hearing. Maybe it will, maybe it won't. I haven't really done any research as to how this applies to an administrative judgment against you. Typically, an administrative judgment has an appeals process, and that appeals process takes you back to whatever court that judgment was originally entered in. So I'm going to say an administrative judgment, this is not going to apply. So it's probably only going to apply really to two situations, but I'm not 100% sure on that. The first situation is where you had a jury trial, right? And the second situation is where you didn't have a jury trial. So either you had a jury trial or you didn't, right? So in either way, you can go back and you can ask for either a new trial or to have that judgment altered or amended. And the reasoning for asking for this is going to be slightly different, and it's going to depend on whether or not it was a jury trial or non-jury trial. And then there's going to be some reasons where it really won't matter if it was a jury or non-jury trial, right? So after a non-jury trial, basically the court can take additional testimony, they can amend findings of fact and conclusions of law, and they can make new conclusions of law. they can also direct the entry of a new judgment, right? So generally, when you're going back to court under Rule 59, you have a limited amount of time in which you can basically ask the court to have a new trial, alter or amend the judgment. And that time is going to be about 28 days. So 28 days is really not your only relief, and we're going to talk about that in the second video. But in this video, you have 28 days, or in this video, we're going to talk about. Uh, so in this video, basically, we're talking about Rule 59, and Rule 59 gives you only 28 days. So that's not a lot of time. That's not a lot of time because typically what happens to some people after they get a judgment against them, they're shocked, right? And it's hard for them to think, it's hard for them to function after you've had a bad judgment against you. And then if that judgment was bogus, or you feel that judgment was bogus or unjust, you're going to be petrified. You're not going to be able to think. You're not going to be able to act. So, in my opinion, 28 days is not enough. It's always good to have a lawyer, and that way it's not really dependent upon you. But of course, a lawyer is probably going to want some cheddar in order for him to go back to court. He's going to want some money so that you can basically file this additional motion. And there could be some situations where the lawyer holds you at ransom until you pay this money. They're not going to do any more work. Or you could be in a situation where you can't basically pay the lawyer because of the judgment, and the judgment against you is basically taking up all your resources, right? So just throwing it out there. So basically, the court's initiative or reasoning, so basically, the court has the ability just to issue a new trial on its own, right? So even if you make a motion to have a new trial, alter or amend, the court can take that motion and they can rule on it. Or if you have, and what they can also do is that they can basically rule on reasons that you didn't even include on your judgment in order to alter, amend, or give you a new trial. And this is why, believe it or not, it's kind of important that the judge likes you. And I know this sounds crazy, but whenever you're going into court, and even if you're representing yourself, or even if you're represented by an attorney, you want to somehow play up to the court liking you. You want to give the court a reason to be biased. And I'm going to get into this a little bit deeper a little bit later. But for now, let's continue on. But just know that the court, on its own motion, or for reasons that you didn't even include in the motion, can decide to have a new trial, or they can decide to alter or amend the judgment. One of the things that comes to mind is that there can be a judgment against you, and the court or the judge can see obvious reasons that this is not right, and they can correct that on their own after the judgment, or even before, during the judgment is rendered. They can correct it. But I'm just putting it out there to let you know that they can always go back and make corrections, right? So, just moving on. So the reasons for actually asking for a new trial, alter or amend the judgment, is there was some seriously erroneous things that happen in your trial, or it's against the weight of evidence. Maybe you went to trial, you put in a lot of evidence that basically showed the court it was supposed to rule in your favor, and the court made some very serious errors, or there is a miscarriage of justice. These are some of the reasons to put in your motion to basically have the court get rid of that bad judgment against you, right? So basically, it says, and this is all case law, right? So a new trial should be granted only where the verdict cries out to be overturned or shocks the conscience, right? So if there's a situation where the judgment against you is just so crazy, it's so outrageous, you have the right to put that into the motion that you're using to go before the court. And according to Rule 59 in jury trials, you can have a chance of having that judgment thrown out, right? So another reason for asking to have the judgment altered or amended or just simply have a new trial, the damages being excessive or the trial being unfair to the moving party in some fashion, or the proceedings influenced by prejudice or bias, right? So of course on my channel I talk about a lot of trials that's being influenced by the media. You could potentially put that in your motion. I'm not sure if there's case law basically supporting that, but you can still put it in your motion and ask. It doesn't hurt to ask. In this situation, you already lost. It doesn't hurt to ask, right? So another reason in non-jury trials is that hold on a second, is that you want the judge to basically weigh the evidence, or we weigh the evidence, and you want to look at the credibility of the witness. I'm sorry. So obviously on my channel I have a lot of cases where I talk about people who are in these situations where the evidence against them is weak and the witnesses that are coming forward are not credible. These are some of the situations where if you're in this situation, where if you have those conditions, you want to go back to the court and you want to have the court to look at the evidence again, and you want to have them look at the credibility of the witness, right? So now let's talk about non-jury trials. So non-jury trials are slightly different, right? Because we're talking about two situations: jury trials and non-jury trials, and both of those have a path that you can go down in terms of case law. Or both of those are two different scenarios in which there's case law supporting asking for a new trial or alternate amending the judgment. Some of those reasons may be the same, they could differ, right? So basically in a non-jury trial, it's a little bit different. And this is why I say you don't want to piss the judge off if you are basically, if you're representing yourself. You want to do everything you can not to upset the judge. And the reason you want to not to upset the judge is because the authority to grant a new trial is addressed to the sound discretion of the trial court. So basically, the judge can do whatever he wants to do. There's no way that you can force the judge's hand in the non-jury trial. You not in this situation in Rule 59. You can't force the judge to do certain things. And there's going to be some situations where you can go to court and you can force the judge to rule on in your favor in certain situations. These are limited situations where you can force a judge to basically rule in your favor. But in non-jury trials, and specifically as it contains to, or pertains, I'm sorry, it pertains to Rule 59. It's to the judge's discretion. They can do whatever they want to do. If the judge doesn't like you, he can say, beat it, and that'd be the end of it. Then after that, you have to go and appeal, right? So it's very important in non-jury trials that you do not upset the judge. You want the judge to like you. You got to do research on your judge before you go to court, and you have to find some way of using nonverbal communication to get this judge to like you. And the only way you can have a chance of doing that is by doing research on the judge you're going before you go before him. It could just be simply based on how you're dressed. If you're dressed a certain way, judges may like the way you dress. And it sounds silly and it sounds trivial, but let's say you find out that the judge is LGBTQ, right? I'm just throwing it out there. So you may not be LGBTQ, but if you lose this case, it's gonna be devastating. So you might want to put on the LGBTQ tie, or you might want to put a LGBTQ pin in your pocket or something like that. To show that you respect that lifestyle. Now, I'm just using it as an example. It could be anything, right? It could be strong passion for kids or something like that. You going to the courts and with a T-shirt on showing that you donate to some kids organization. It could be anything, right? I'm just throwing examples out there. But at the end of the day, you want the judge to like you. You want the judge to like you. Maybe the judge served in the military and you go in with your military fatigues on because you served in the military too, or you go in and you can put on camo gear. It can be anything, and nothing is guaranteed to work. Is just to try. But I'm going off on a tangent here, but I'm just trying to point out the fact that you want the judge to like you in the case, because the judge has discretion to do whatever they want to do, right? So anyway, moving on. Basically, in non-jury trials, one of the reasons for getting a new trial or altering amending judgment is to correct errors in law or fact. So maybe there was some type of error on the fact level. Maybe some of the facts that were presented to the court was wrong. Maybe some of the law that was presented to the court was wrong. Maybe the judge misinterpreted or you believe that the judge misinterpreted some of the law in this case. At any rate, these are reasons to go back and ask to have the judgment thrown out, right? So, and it's also appropriate, just like in jury trials, where there's a clear weight of evidence, and I've already basically covered that. And there's also a justification in a situation where they've actually changed the law, and this is a little crazy to me, right? For example, let's say in 2013 you go to court, and you go to court based on some law that was in effect, and then let's say 2017 the law changes, right? You've already won. Now this person gets to come back because of a change in law and because of some political circumstances that caused the law to be changed. Now they can come back and basically ask for the case to be reheard. Now here it's saying 28 days, as I read before, but I don't think this is going to be limited to 28 days. Another reason for going back to have a judgment thrown out, have a new trial, amend a vacated judgment, is that there would be a serious miscarriage. So that's pretty much it for this video. The next video, we're going to look at some other mechanisms you can use to basically get rid of a judgment against you. And in the other video, we're going to talk about the time constraints and how the 28 days doesn't apply. It could be a situation where you've had a judgment hanging over your head for decades and you want to get rid of this thing. There's a way to go back when it's beyond 28 days, right? So please like, share, and subscribe, and leave your questions and comments below.